Sentencing.
One right here.
Good morning, you're senior. And Mr. Lamel was previously in court and entered a plea of true to count 1 in a motion to revoke deferred probation on probation for evading arrest or detention with the use of a vehicle. And that was from February 17th of 2025. Count 1 that he pled to was the count where he was arrested for a burglary of a habitation. It was not necessarily that he had committed it, but that he had been arrested for it.
And Judge,
Go ahead.
So you're aware, the motion reads kind of funny that you pointed out to us last time. So I could technically abandon 1 and 2. I just kept them there for your review. Have corrected them in 7 and 8, I believe.
Okay, so
That's
there
why
was a
it's
first amended.
Yes, ma'am.
So we need to go through that first amended.
Correct. And then Ms. Branch will be here to testify in place of Ms. Jefferson if those pleas don't change.
Okay, hold on a second. Let me pull this up correctly. So let's go through that motion. Mr. Lamel, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can put your hand down. And will he waive the formal reading of the first amended motion to revoke unadjudicated probation?
So waived.
So again, and this is 24 DCCR 0826. You have a first amended motion to revoke your unadjudicated probation. Shows you were placed on probation February 17th of 2025 for evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? It alleges you violated your probation, and I'm going to go through the whole thing again, just because I don't have the other one right in front of me. It'll be easier. So count 1 alleges that you were arrested. Okay, so did you want to...
Abandon 1 and 2.
Inside the courtroom, the air is tense. The judge begins the sentencing of Mr. Lamel, a man whose probation now hangs by a thread. Every word could decide his freedom or his return to prison.
Probation?
Correct.
Okay. So 1 and 2 will be abandoned. So count 3 alleges that you failed to report as directed to the probation department March 5th and April 9th of 2025. And is that true or not true? True or not true?
Is that true or not?
Count 4 alleges that you provided a urine sample May 1st of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true? That's marijuana, THC. Count 5 alleges that you were at a location other than your residence at approximately 3:01 a.m. April 26th of 2025 in violation of your probation. Is that true or not true? Count 6 alleges that you failed to abstain from the use of any and all intoxicating substances.
Mr. Lamel once had a chance, a deferred probation for evading arrest. But now, the court reads new violations, missed check-ins, failed drug tests, and broken curfews.
You committed the offense of burglary of a habitation April 26th of 2025, and is that true or not true? And count 8 alleges that you failed to avoid injurious or vicious habits and refrain from behavior harmful to others, and that you were aggressive towards both Beaumont police officers and the complainant, Aronia Parkerson, on or about April 26th of 2025, and is that true or not true? Count 9 alleges that you provided a urine sample May 1st of 2025 that tested positive for ecstasy, and is that true or not true?
Your Honor, if I might, I don't think ecstasy is listed in the Controlled Substances Act. It would be MDMA. That's the Rich Street vernacular for me.
One by one, the judge asks, true or not true? Each answer weighs heavy. The truth isn't just spoken here, it's judged.
Would be characterized as ecstasy. If they want to amend to allege MDMA, that would...
Ms. Malfino?
I'll make that oral amendment, Judge, to change ecstasy to reflect MDMA as worded in the Controlled Substance Act.
All right, so any objection to that?
No objection.
All right, so that count 9 alleges now that you provided a urine sample that tested positive for MDMA, which is also ecstasy. Is that true or not true? Did you enter your pleas of true to counts 3, 4, 5, 6, and 9 freely and voluntarily?
Yes, no.
And because they're actually true.
Yes, no.
All right, so with regard to the burglary of a habitation, Ms. Malfino, what is the state's position as far as wanting to, do you want some time to
Judge,
prove that, or?
I will defer to whatever the court would like me to do. The complainant in that case
A burglary of habitation charge lingers, not proven but haunting. Even an arrest, the judge reminds, carries consequences in the world of probation.
to that injurious or vicious habits in her reflection or read of the police report if Mr. Kimmler wouldn't object. Otherwise, if you would like me to get those officers to detail his behavior on that night, I can do that, but she has not been cooperative with me.
Okay.
Obviously, Your Honor, I would like the opportunity to cross-examine if the state does attempt to prove that up. I would just observe that whatever conduct Mr. Lamel did engage in didn't result in criminal charges being filed to the level of resisting or harassment or anything of that nature, retaliation.
So we already did the updated pre-sentence report, and the recommendation in that report, it was unagreed, and the recommendation at that time was that he would benefit from both tracks of ISF. Can't do both tracks, but go in and do the substance abuse track, followed by JCDI, anger management. Ms. Malfino, since it can't go if the other case is pending, I guess based on what you're telling me about the complainant in the other case, what is your position on that?
To not proceed on that case, Judge.
Not good for your baby. Not good for your relationship. The judge's words cut deep. A reminder that choices ripple far beyond the courtroom.
Your position?
Yes, ma'am.
Cognitive track or substance abuse, Your Honor?
Well, substance abuse is clearly an issue. I think I would rather do substance abuse and then JCDI and then whatever other behavioral thinking,
You mentioned-
moral recognition or something like that once he's out, and so that we get the more intensive substance abuse before he gets out for JCDI would be my thought. What do you, or would you think cognitive track would be better? You do? Okay. So what is the status of the relationship with the complainant? What's her name?
Ronia,
I'll represent to the court.
Aronia Parkerson. I'm asking him. I'm asking
I
him.
understand, but she's present outside of the court.
Okay. So what is your status of your relationship? Are y'all still together?
Yes, no.
Do you want to ask her some questions since she's here?
maybe so, Judge, if I may. I didn't realize she was.
You want to go visit with her for a minute, or do you want to have her
She's outside.
brought in?
Oh, we can just have them run.
Would you please call the name Aronia Parkerson?
So, drug substance abuse, contract information.
If you'll scoot over just a little bit towards your attorney. Ma'am, come right over here. You just come on up right here. Would you please state your name, please? When you hear out loud what you did that night.
A little disappointed.
Instead of prison, the judge offers one more chance. Probation extended by a year. A final opportunity for change, not punishment.
What I'll do then, based on that and based on her representations and probation's willingness to try to help you so that you can be successful, is I'm going to find that you entered your pleas of truth to counts 3, 4, 5, 6, and 9 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to follow this agreement, or not agreement, I'm going to follow the recommendation, and I'm going to continue you on probation. I am going to extend your probation for 1 year I'm going to order that you enter and successfully complete the substance abuse track of the ISF program. And then when you're released, your aftercare will be through the JCDI program. You will also be required to follow any other new recommendations or classes with regard to making better decisions, cognitive thinking, things like that. This is all meant to help you be successful. I want to make sure you...
The court decides Mr. Lammel will undergo intensive substance abuse treatment. Before justice can heal the system, it must first heal the person.
I'm sorry?
I'm sorry, I didn't.
Yeah, no, you're not gonna get all of this again. Does that make sense? You're likely gonna be going to prison, and you could go to prison for up to 10 years. You could do that today. I could send you to prison for 10 years just for the violations you've already had that you agreed to, the testing positive and all that. I don't need a new case. I don't need any of that. I can send you to prison today. I don't want to do that. I want you guys to work things out, but you've got to make things where that works in a very productive and nonviolent and non-confrontational, sober way. Okay? So, probation will let you know what all, again, that you need to do, but you'll go from here to ISF. Once you get out, you'll be in JCD.
As the hearing closes, the complainant, Aronia Parkerson, is called forward. A quiet moment of confrontation or forgiveness hangs in the air